Wonderful. So usually I develop a seminar around associated topics in cryptocurrency, blockchain, and mining, and it takes anywhere from 2 hours to 6 hours to deliver. I'm going to try to condense all of that in 15 minutes. So buckle in. Okay, just a quick overview on what we do. Actually, I believe that was already given. So we serve public companies, SMEs, startups, and high net worth crypto holders in the blockchain and crypto space, inclusive of miners. Everything that I'm about to say comes from research conducted in various areas of federal legislation and Ontario legislation, primarily federal. If you want any more detail on anything I have to say, I encourage you to go to smartblocklaw.com, and all of the multi-part legal resources are there on the website for you to delve into, and they're completely cited if you want to hold me to task. Now, today we're here primarily concerned with crypto mining operations. Crypto mining operations obviously involve blockchains, and blockchain networks or distributed ledgers require nodes. Now, the proliferation of data across 2 or more nodes necessarily involves the transfer of data, often across borders. So what that means is even if you're mining cryptocurrency and creating something new, because you're writing data to nodes potentially in a variety of jurisdictions, you're going to be invoking the laws of a variety of jurisdictions in a variety of areas. Now, the internet has involved to date a transfer of information. This may have been covered before, but I think it bears repetition. Information transferred across borders in certain cases can be problematic. For example, we see that in non-blockchain areas in privacy law, cyber defamation, and free speech. Again, I'm not going to go into too much detail on each, but happy to have a chat with anybody who wants to talk to me about this after my presentation. Now, blockchain technology sits on top of the internet and facilitates a transfer of value rather than a transfer of information only. Value transfer is governed differently within numerous areas of regulation and between jurisdictions, as we'll come to see. On this basis, what every blockchain business needs to do, including miners, is to develop an operational strategy for cross-border blockchain operations. At present, it can feel like developing that strategy is a bit like playing whack-a-mole. So, for example, you can optimize a certain part of your business plan in one jurisdiction only to find out that that optimization has hurt you in another jurisdiction. So, for example, as we'll come to explore, on the securities front, if you have a sufficiently decentralized network, that can be helpful in the U.S. in securities law, but that could hurt you in the EU with respect to privacy law. More on that to come. Now, at present, various bodies are in the process. Various bodies are in the process of formulating blockchain regulatory frameworks, but there's no international framework yet. And I've been advocating for at least the last couple of years that this is what we really need to see a proliferation of this tech going forward. Again, this applies as much as it does to the crypto mining sector, to any other blockchain business. So what we have are a patchwork of varying and sometimes conflicting national and regional regulatory regimes. So any blockchain venture seeking early market share should be aware of major legal issues invoked by blockchains across borders. The key takeaway is that it's impossible right now to optimize both early market share and regulatory compliance. I'm going to say that again because it's so important. It is not possible to optimize early market share with regulatory compliance. If you chase after market share, somewhere on your regulatory compliance side, you're going to be deficient, and you're going to be asking for a regulator to come enforce against you. On the other hand, if you put emphasis on regulatory compliance above all, that will take so long, just because of practicalities in the space, that you will for sure lose early market share to a competitor. So any blockchain business, again, miners included, will have to optimize their risk according to the various areas of law invoked. And that's the big takeaway for today. Miners and anybody investing in miners, you have to be prepared to assume risk, but just make sure you know what your risk is in order to optimize it. Now, obviously, understanding your risk profile requires an understanding of the primary blockchain law issues, which we're about to jump into. I won't be covering AML or litigation, both for time and because AML was previously covered. Let's get to it. Blockchain law is an umbrella term consisting of three primary subgroups. So the first would be corporate funding, and we've all heard the term ICO, so that's where ICOs would primarily fall. The second is ongoing blockchain operations, which not a lot of people put a lot of attention to, but that actually is, I find, the most interesting area and invokes the most, the hairiest issues that need to be dealt with. And the third area, of course, is enforcement and litigation, which we're not going to attend with today, but that's essentially when any of the other two areas, something goes splat and you have to deal with it in court. This is the area of law that gets invoked. Quick disclaimer, this is informational information, particularly since I'm trying to condense 2 to 4 hours into 15 minutes. Myself, my firm, and the MPWR Summit organizers aren't responsible for any information that you rely on here today. You should obtain formal legal advice particular to your situation. Get in touch with me. Okay, now if this were a full presentation, these are a subset of the issues we'd be looking at. And this is typically what I cover in a full day seminar. So again, love-hate story with blockchain and the law, corporate funding involving securities issues, and then those are all, of course, the sub-issues. I won't get into each of them in detail, but I'm sure the conference organizers will give out this presentation if you ask. And then ongoing blockchain operations, where I'll spend a fair amount of time today. As you can see, most of the meat is in ongoing blockchain operations, and to date, there hasn't been a lot of attention spent in this area, and as a result, we have, quadriga happening. Had these areas been paid more close attention to in the course of their operations in prior years, quadriga may not be in the situation it is in today. And then, of course, obviously, enforcement and litigation. I'll share some final thoughts very briefly at the end if we have time, but let's first get into the actual meat of what I want to tell you. So, with all the areas that are invoked by blockchain operations, once again, just a quick sampling would be securities, AML, tax, crypto contracts, which nobody seems to be considering these days, and financial institution and fiduciary issues. With all of those areas of law, there are three observations that I've made. One, they treat blockchain activities different within jurisdictions. Okay, each one of those areas, the tax law will treat blockchain operations different than your anti-money laundering law, which is different from the securities law treatment. And then between jurisdictions, all of these areas of law are substantially different. And what makes things even harder is that these areas of law are constantly changing. But blockchain ventures often need to operate across borders in many different countries. So, what do we do? The question is, how does a crypto mining company devise a consistent set of operations while being compliant in all jurisdictions that it operates in? Easy answer is it cannot. Right now, it cannot. It's not practically possible. You will be assuming risk, as I indicated earlier. The question is how to optimize it according to your comfort level and the comfort level of your investors. Now, the best regulatory response would be an international treaty. Again, we don't have that yet. Until then, we've got something called the Global Financial Innovation Network out of the UK. The Ontario Securities Commission is a member of that network, I'll note. And of all those member organizations, I note that the Securities Exchange Commission in the U.S. is conspicuously absent. So what does that mean going for the future? I'm not sure, but it doesn't really contribute to to assure regulatory landscape at this time. And until we have a more certain regulatory landscape, I'm sure that we're going to get more decisions like the copy-track decision, which actually came out of BC. In that decision, the judge it decided to trace cryptocurrency, which means when cryptocurrency was transferred from person to person, the judge essentially went from person to person to find that cryptocurrency, even though it didn't actually know what cryptocurrency was. And by that I mean it couldn't firmly define cryptocurrency. That's a problem in my mind. And this is something that I think further cases will clarify, but again, we're not there yet. So the first area of substantive law that applies is corporate funding. And my goodness, I already noticed that I've burned through most of my time. But very quickly, corporate funding is meant to protect investors. Why is it important to cryptocurrency and digital token miners? Because how the cryptocurrency is transferred will often invoke securities law. And presumably when you're mining cryptocurrency, the point is not just to hold it, but to eventually transfer it. And that transfer is what might attract securities laws. Very quickly, if you are a security, there is a prospectus requirement that is lengthy and expensive. There's a registration requirement. And if you are operating as an exchange as well as a miner, there may be a further application that needs to be filed in every jurisdiction in which you operate. So obviously, you don't want to be a security. You don't want your tokens to be securities. Now, I'm going to race through a few slides so that I can cover as much as possible, including the investment contract test. But again, all of this is available on the Smartblock Law website. Okay. In Canada, the points to keep in mind is that when a regulator determines whether your token is a security, there are four main values that it will consider. One, the objective of investor protection will be all important. Two, a token can be a security notwithstanding its utility. And this is very important because there used to be, for some reason, a distinction in industry between a utility token and security token. That always had irked me because they are not mutually exclusive categories at all. You can be both. And finally, freely distributed tokens can still be securities. So airdrops, for example. Now, some of you may be thinking right now about blockchain, the company in the US, which uses airdrops to proliferate its network. I can't get into that right now, but I do have strong views about it. We can talk after. Okay. I won't touch the SAFT either here today. I don't think we'll have that time. The last issue in securities law that I'm going to touch upon is something called sufficiently decentralized. According to the U.S., if your network is sufficiently decentralized, you are not a security. However, the U.K. securities regulators have said the exact opposite. So, again, we're left in this land of limbo between jurisdictions and how your blockchain should operate. Now, the next area of substantive law to deal with is taxation. Again, I don't think I can deal with all of them, but taxation is an important concept, including, or particularly now since we're reaching April and tax time is upon us. The CRA has recognized cryptocurrency to be money, a commodity, and a payment system. And as I'll explain, it's strange that it would recognize crypto as a form of money because according to our federal legislation, crypto cannot be money. In fact, it's illegal if you consider it money. Now, income tax will change depending on how the crypto is characterized. Now, in the case of a crypto mining operation, it may be characterized as inventory. In fact, that's one of the specific areas of opinion that the CRA has provided its opinion on. It can also fall under the category of gift. It really depends on how the cryptocurrency is treated. Any question in the tax field is going to require a specific set of facts to deal with, to deal exhaustively with any question. There's so much I want to say, but I can't. So I'm gonna skip ahead to the next area. Right. If your crypto mining operation happens to be a trust by virtue of the relationship it has with users or any other third party, then there may be tax obligations that you have because you're holding potentially crypto that belongs to other people. Okay. The next area, and I'm sorry I have to speed through everything, but this is kind of the nature of the beast, is crypto contracts. And I think this is an important area because a lot of people out in industry are treating cryptocurrency as money, as if it's a medium of exchange that can function as money, when in fact, legally speaking, it is not allowed to function as money. Technically, you have an illegal contract if you're treating it as money. And the reason is in Canada's Currency Act, which states in reduced form that the only substance that can be money, quote unquote, is currency that is released from a national government. So in other words, fiat currency. You cannot have non-fiat money. It doesn't exist. Not yet. And we have a similar definition coming out of the U.S. Commercial Code. Again, in reduced form, money comes from governments. Now, you might be thinking, what about stable coins? Well, I've got views on that too. Let's talk after. Next area would be financial institutions. This is an important area that I identified last year. Nobody would listen to me, and now we have Quadriga, so there. So here's why I think this is important. When you have an exchange on which you can create a user account and you can deposit fiat funds, you can withdraw fiat funds, you can trade between cryptocurrency and fiat currency, I mean, to me, that sounds a lot like a bank. And the funny thing about the legal definition of a bank is that it's very nebulous. The definition of banking has changed from era to era, and we still don't have a concrete definition that allows us to peg what exactly banking is. Now, that's a shame, because if you are a bank, technically speaking, you should be registered under the Bank Act, and then, of course, you're subject to regulations under the Bank Act, including cybersecurity measures, which recently came into effect late last year. Now, it's all well and good if we have the AML side of crypto regulation being developed, even though we don't have the draft regulation in force yet. But if you're a bank and you're not being regulated as a bank, I think there's potential issues that may creep up. And Quadriga, prime example. Now, let's say you are not a bank. Let's say you're a crypto mining operation and you don't permit user accounts. That's not to say that you won't subsequently transfer your tokens and invoke securities law, but let's just say you're not a bank. Even still, you may owe what's called fiduciary obligations. Fiduciary obligations are obligations one party owes to the other just by virtue of their relationship. So consider, for example, whether the miner operates also as an exchange. Consider whether the relationships with third parties involves an expectation of duties owed by the miner. And consider whether there's any disclaimer in the miner's terms of use that can contract out of certain fiduciary duties. Sometimes you can contract out of your fiduciary duties. Again, the ongoing case of Quadriga CX. You've probably heard about Quadriga ad infinitum tonight, so I'm not going to go in detail on there. I have been quoted by Canadian Lawyer Magazine, the Vancouver Sun, and a few others, Bitcoin Magazine, on my views about Quadriga CX and what's going on there. Again, all accessible from the website. Next substantive area of law would be IT contracts. IT contracts are necessary for any tech company. It's not just crypto miners or blockchain companies. And just for example, you have third-party vendor agreements. With the new wave of AML regulations is the ability to contract out your KYC obligations. So you can actually hire third parties to do KYC. Well, if you do that, you probably want to offload as much liability as you can to the KYC operator. That's the job of an IT contract. You may also have node agreements, or you should have node agreements. So, for example, if you're a big Bitcoin farm, if you're a group of small miners operating out of a dorm, for example, and you're trying to pool your resources together to compete with the big Bitcoin farms, you'll probably want an agreement between you to split the spoils later on, determine what happens in the event of a dispute, etc. That's the job of a node agreement. Same thing with a mining coalition agreement and browser app agreements if you're operating as a platform online. Now, on the data privacy front, in one foul swoop, I'll just say that if you're putting your information on a blockchain, one of the cornerstones of data privacy is that you provide consent, but also that you can withdraw your consent. But one of the problems or complications that arises with a blockchain is that it's immutable. So how do we deal with that in the context of the consent required under privacy laws, not just of Canada but also of the EU? Less so much in the U.S., where they view privacy more as a property right rather than a fundamental right. But that is something that will have to be dealt with. And again, it'll have to be dealt with potentially differently in every jurisdiction in which you operate. Now, on the data breach and cybersecurity side, at least in Canada, we have mandatory breach notification and reporting since November 2018. I think this is important in the crypto space, including the mining space, because breaches have been a prevalent problem in this industry for, all the way back probably before Mt. Gox. Now that we've got stronger data breach and cybersecurity framework in place in Canada and developing worldwide, that should be taken into account by any platform operating in this space. In Canada, your failure to sufficiently notify a report may invoke a fine upwards of $100,000. If this is new information, don't feel bad. This is new as of November 2018 in Canada federally. Now, in terms of a cybersecurity standard, we have standards, or we have guidance provided by the Office of the Privacy Commissions in various decisions. We also have best practices, privacy by design, etc., that should be considered in any cybersecurity plan or breach plan. Now, why do you need a breach plan? Well, because eventually you're going to get hacked. That's just the nature of cybersecurity. Any platform will get hacked. So it's not a question of if you get hacked, it's a question of when. And the raison d'etre of a breach plan is to minimize the delay to react to the breach. It's to maximize the effectiveness of your reaction to the breach. And it's to minimize liability for the breach and minimize damage caused by the breach. So, for example, the question of whether there is a breach at all is a legal question. If you react in just the right way, potentially your lawyers in the future can defend you to the extent that maybe there wasn't a breach. Maybe you're not liable. Maybe you took reasonable measures. I would love to continue on this path. There are several other areas: smart contracts, insurance, again, enforcement, litigation. This presentation, again, I think deserves to be given in its full length at the 6 hours that I usually give it. But I hope I've given you a taste of the legal issues that you need to consider in every jurisdiction of your operations and why it's so vitally important that you contact a lawyer, because in any business, a lawyer is important. I think that's particularly true in a crypto or blockchain business because of all the complexities involved. Thank you very much.